So I'll start with, I know what's coming up. I've had a preview. My name is Cliona Saidlear. I am the Executive Director of Rape Crisis Network Ireland. So we're the body that the Rape Crisis Centres in Ireland, which there's 16 rape crisis centres in Ireland, which come from the 1970s feminist movement, specifically dealing with sexual violence only. And they set up the network, which is the RCNI, to basically do all the work they wanted to do together, which was to build a platform for change, to have learning, and to have a network, and to have connectivity, and to have accountability to each other, and to get the best out of everyone, and to deliver the best for survivors and for change. So, I'm kind of asked to talk about the legal change, but I'm not really going to talk about the law per se in the way that you might expect, because I think most of you in this room are familiar with European law. You'll be familiar with the directive, with the Istanbul Convention. I'm not going to repeat them to you. What I do want to do with the opportunity that was given to us is to reflect a little bit about the dynamic of the law and change, and society and culture, and how those two work together. And I had picked 3 examples. I think I've only got time for 2, so I'm going to give you 2 recent examples in Ireland that will allow me to explore what we're talking about here. And the first, you might be familiar, we had a referendum in Ireland last year, a referendum on the right to access abortion. That's not really the referendum I want to talk about. I want to talk about the referendum that got us there in the first place. And the second, I want to talk about the new Sexual Offences Act, the new code, excuse me, in 2017. And again, it's a very big piece of law. I just want to talk about one piece, and that is the piece about consent. So, let me start with the referendum that started us off on the journey that got us to the 2018 referendum. There we are. So, 1983, I was 11 years old, and they had a referendum. And this was the referendum. This was what they asked the Irish public that we would put into the Irish Constitution. Constitution, of course, being the most fundamental piece of law that we have. And the key here is that they asked the Irish people to acknowledge the right to life of the unborn and to put that in the Constitution. I distinctly remember as an 11-year-old girl, because the thing about a referendum, when done properly, is that it engages the whole population. It is the most superb and sublime and terrible democratic process. Everybody gets involved. So as an 11-year-old, I couldn't avoid the conversations about this referendum. And so I tried to understand it. And I distinctly remember having a conversation with my father. And I said to him, I said, does this mean that because I'm a girl, when I get pregnant, my body isn't my own? Does this mean that because I'm a girl, when I get pregnant, that somebody else can make a decision about my body that I don't have to consent to, and that I can't consent to, even up to death? And my father said, yes, that's what it means. And my father voted yes to put that in the Constitution. 67% of Irish people put that in the Irish Constitution in 1983. I was 11 years old. As it happens, in these sort of coincidental things, I had just got my first period. I had just started my cycle of fertility as a female. And this is now my landscape. We often think of the law as something quite remote and removed, and something that we may encounter when we get to a courtroom. What I want to talk about is how this piece of law actually spread out and infiltrated so many aspects of our lives and had an impact that rippled and rippled and rippled. This amendment remained with us for 35 years. So we had 35 years of this amendment building culture in our society. And it didn't, it really only came out bit by bit exactly how it had impacted. And really at the very end of that campaign for the repeal of this amendment, to get this amendment out of the Constitution again. And when I say the campaign, really the campaign was 35 years. There were people campaigning from the minute this was in the Constitution to get it out of the Constitution again. And it grew and more people became involved, and at some point it became more publicly, moved into the public domain, and until it really exploded onto the scene, maybe 2015, 2016, 2017, and then we finally had our referendum in 2018. And many people started to come out and say, this is how I think it's impacted me. This is what's happening for me. This is my experience in Ireland because of this. Because you would imagine that the people who voted for this, like my father, weren't necessarily, they weren't bad people. They were just focused on the preservation of the life of the unborn. They thought they were doing a good thing. And they believed very sincerely, and some of them still do. This was their objective. They were thinking about the unborn. They didn't think about the unintended consequences of laws. One would imagine that it only impacted on women and girls when they sought abortion. It did that, but it did a lot more. It ended up impacting all women throughout their entire fertile life cycle. Because as people and as the courts began to interpret this, it turned out that we became, because our rights in the Constitution, it said we only had human rights to a point. And at a certain point, they would be removed. And the point at which they would be removed is that we had the capacity or the possibility of being pregnant and giving birth. So I'll show you one of the things. Oops, there we go. So this is the National Policy on Consent by the HSE, which is the health care service, the statutory health care service in Ireland. This is the National Policy on Consent for patients, for everything. And it's very detailed. It gives really, really good power and empowerment to patients, except 7.71, where it says, except pregnant women. So there's significant legal uncertainty regarding the extent of a pregnant woman's right to refuse treatment. This didn't, of course, just in practice mean pregnant women. It meant women who might be pregnant. So doctors talked about how in A&E, if someone arrived, if two people arrived in from a car crash, and one was a man and one was a woman, the man got instant treatment. The doctor had to determine if the woman was one patient or two patients, because the doctor had a legal obligation to an unborn child. So it impacted right there. So it impacted all women in our medical care. And we almost didn't even realize this happening. So this law, this is what I'm saying about how law can impact. It impacts positively as well, because obviously we use law to insert a change into our culture to effect change. This law, it shows us just the impact of a law can have, even when we're not paying attention to it. We had it for 35 years, so 35 years of forming our culture. We still have a medical culture that is nervous of treating women before they know whether or not they're pregnant. But we also had a lot of test cases, legal test cases. These were the really hard cases. These were the ones that ended up in court and ended up in the High Court because they needed an interpretation of what the Constitution meant. The X case, Miss C case, Miss Y case. Towards the end of the 35 years, it was often commented that we were going to run out of letters of the alphabet because there were so many really horrific cases, and every time we thought we'd experienced the worst one, there was another one that was worse again. Many of these cases involved rape victims, and many of them were children who were rape victims. So when it came to the referendum, and thinking and preparing it to the referendum, what was really clear was that rape was already right in the middle of this conversation. Rape survivors, rape victims would be in this conversation, and they would be used in this conversation, one way or the other, whether they liked it or not. Already there was a certain question around the hierarchy of those who are worthy, the worthy and the innocent, who might have access to abortion and those who might not. So we couldn't not talk about rape survivors in this referendum. It was something that we had to talk about. The only decision we had to make was how are we going to intervene in terms of our responsibility to survivors. And our objective was quite simple. We set out to make it fact-based and as objective as we could. And we set out that survivors would be treated with compassion and dignity at all times in this debate. And we put out a fact sheet based on our data from rape crisis centres, and we started talking about rape and rape and abortion. And we simply put out this dispassionate fact sheet. Because you had the sensationalisation of rape and pregnancy all the time. We said, no, we're going to be transparent and open, and here's the facts.
What's on it? I can't read it.
So this is the first fact sheet we put out was the 2010 data. I think we released it in 2013 though. So in that pie chart you will see that 57%, and this is only representative of the survivors who came to rape crisis centres, not the general population. But of those who came to rape crisis centres in 1 year, 57% parenting, 13% had a termination, 13% had adopted or fostered the child, and 12% had miscarried that pregnancy. And the small percentage there is a combination because there was multiple pregnancies in 1 year. These are very small numbers. But this allowed us to have a conversation. And we put out, obviously on the back of those, a set of opinion pieces and more considered pieces, which really talked about the whole range of contexts, pressures, reasons, choices that survivors might make and why they might make it. And really the point for us was, nobody knows. Nobody's in that survivor's position, and nobody has the information to make any kind of value judgment about why a survivor may or may not keep their child and what they may do with the pregnancy. I'm going to switch now. I think by and large we succeeded in that. Survivors did not get used in a sensationalist manner. As the campaign in the last few years kicked in, we got, of course, the usual young people arriving in with American accents, telling us that they were survivors of rape and that they kept their pregnancy, or that their mother was a survivor of rape and had kept their pregnancy, and otherwise they would have been aborted. And these sort of sensationalist uses of rape survivors and the choices that they might make. And we simply went back to our fact sheet and said, oh yes, of course, survivors make all sorts of choices. This is one choice that survivors make, and it had no power anymore. The second example I want to talk about is the legislation. And there's a lot of things that came together at the same time. So this legislation, as you can see, was 2017. So this conversation was happening at the same time as the conversation about the referendum. And we centred the conversation on consent, because of course the referendum was also about consent. And I'll talk about the definition, and congratulations Croatia, you also have the definition recently in. Now we were already quite progressive. In our law, it was well established that you did not have to voice, and you did not have to know, and you did not have to fight and physically resist in any way for it to be understood that you had not consented. So, by standards, that was already fairly progressive. But we decided we needed a definition also, and a positive definition. And the reason we decided that was because in our courtrooms, the defendants were saying, oh, I misunderstood. I didn't really get it. I'm innocent because I'm ignorant. Poor me. And we said, well, we're here to help. So we're going to help you. So we drafted this. And literally, the RC and I drafted this consent clause. We drafted it 10 years before 2017. That's how long lobbying can take. And we submitted it to the Department of Justice, and we submitted it elsewhere, and we worked on it. This is almost, it's about 90% of the original draft. It's about the same as the one we drafted. So what did we say in our consent, in our wonderful consent clause within our legislation? Well, the first part is positive. So this was a new thing for us. And the positive part is a person consents to a sexual act if he or she freely and voluntarily consents to engage in that act. Simple. Still confused? Okay, we can help further. So a person they'll tell you what consent isn't. So consent isn't when someone is asleep or unconscious. Is that not enough? Okay, but we've more. We have more, we can tell you more, we can help you a little more. Consent is not when he or she is mistaken as to the nature and purpose of the act. Consent is not hatred. Consent is not when the only expression or indication of consent or agreement to the act comes from somebody other than the person himself or herself. Are we clear? No, you need more? Okay, we got more. This section does not limit what consent is or is not. It can be anything else also. Consent to a sexual act may be withdrawn at any time. And the failure or omission on the part of a person to offer resistance to an act does not of itself constitute consent to the act. That's our consent clause within the 2017 Act. In some ways, it's all common sense. And really, we didn't need it. We all understand consent already. What did we put that in there for? We put that in there because defendants were using the oh dear, I'm making, oh, silly me, argument in court. I said, oh, we're going to take that tool away from you. That defence is now removed. You can no longer plead that sort of misunderstanding and ignorance. But we all know, and indeed we have sufficient evidence and research, particularly from psychology, to talk about how people do indeed understand, the vast majority of people negotiate consent all the time in their daily lives. And the only form of consent people seem to have a problem with is when it comes to sex. Because we negotiate all sorts of consensual acts and relationships in our daily lives without any problem, without a need for this list. So, in many ways what we've done is we've taken one tool of defence away. Bad news is there's always the goalpost. Every time you answer a question, it simply opens up the new frontier. So I would say that the new frontier is cultural grooming, and I think we're already quite a long way into it. It's been happening for some time. But this is where, again, what happens over and over and what we have to expect is that the positive things that we develop, such as sexual liberation, which is a positive thing, becomes perverted and turns against us. And this has been, so sexual liberation in many ways in our culture, in many locations and for many cohorts in our culture, has become, has turned on its head. Sometimes people talk about pornographication. But what it means is that if everyone is consenting to everything all the time, so the question of consent disappears. It doesn't matter about defining consent anymore because everyone is up for it. And I'll give you some concrete examples of where that is slipping in here. But I think that's our next challenge, is finding a way to remove this tool from defendants in the courtroom. Here's a headline. Man who said girlfriend died after rough sex, convicted of manslaughter. There's more and more of these cases, and you'll see more and more of these headlines. This is a case that happened in the UK at Christmas. Natalie Connolly was the name of the woman who's dead now. She was found at the bottom of the stairs, his stairs. She had died of her wounds. He had left her there, he hadn't called an ambulance. She had 40 different physical injuries to her body. including a fractured skull where it was fractured so badly her eyeball had popped out of her head. And he went to court and said it was a sex game and that she had consented to that violence. And he did not get murder, he got manslaughter. And he got 4 years. He's probably going to go to jail soon. So this is what I mean by how consent is going to become something that is used by defendants. So let me take you back. I'm out of time, I think. Let me take you back. This is our very last slide. So, on the good news, we got to May 25th, and we had our vote in our 2018 referendum to get rid of that first amendment I showed you about the unborn child. The vote was 67%, this time 67% to throw that amendment out. So we had a very big celebration, it was a very big margin of win. But what I want to say to you today about that 67%, what it hides and what many people don't realise is that in the campaign we didn't really change anyone's mind about abortion. We didn't ask anyone to change their mind about abortion. We didn't make it about that. We asked people we talked about women and we talked about girls. And a very significant proportion of that 67% still do not agree with abortion, but they voted yes. Because while they would say, I do not agree with abortion, they will follow that up with, but I do not believe anyone has the right to tell a woman what to do with her body without her consent. This was a referendum about women's autonomy and women's consent. So I think this is the really good news here. So we have the positive. Thank you.